Yes.
She says with due modesty. Over 6 million votes, outpacing everybody as best I can tell, including the president. So we can congratulate her, and there have been others on our committee that have been successful in their elections. One election may still be too close to call, but we're monitoring that. Just as Christopher is smiling knowingly, and
I am ahead by 4,305 votes.
all right, over a multi-county area. So there have been thinner margins than that in the past. So, well, great. Well, welcome everybody. Another Zoom meeting for our committee. You'll notice, if you're looking closely, that Dee Dee Jones is not here reporting our meeting today, but she is replaced by the able substitute Terry Lynn Workman. Terry Lynn is a terrific court reporter, and he's going to take down what we say today. And Terry, you will notice that we go in order, and the next order is for the chief to report on the goings of the court and as it relates to this committee and other things. So Chief Justice Hecht, who I should mention, is also newly elected to another term. Congratulations.
Thanks, Chip. All the high court incumbents, as you probably know, were reelected, and none of the races was especially close. And so we're pleased to have that done for another time. And we're counting on Chip and others to change this system one of these days. But meanwhile, we survived another election cycle. We have a new justice, Rebecca Huddle. Rebecca was appointed by Governor Abbott just a couple of weeks ago. She is a first-generation American. She was born and raised in El Paso, and then she got her undergraduate degree in Stanford and her law degree at the University of Texas. And she practiced for a while at Baker Botts before she was appointed to the Court of Appeals in Houston, where she stayed for about 6 years. She was elected after her appointment. Then she went back to Baker Botts for a couple of years and has most recently been the partner in charge of the Houston office. We had a very nice swearing in for her the other day in the courtroom, all masked up and socially distanced, and are looking forward to a formal investiture when we can have the use of the House chamber across the street. But the House itself doesn't know when they're going to have the use of the House chamber, so that may be a little while before we're able to celebrate her appointment to the court appropriately. The court is continuing to work remotely. We have not met in person since March. Our oral arguments have been conducted remotely. Our legal staff are mostly working from home, so it's their choice. And a few work in the office, but it's mostly teleworking. And the court is completely current. Teleworking hasn't hurt us at all. We're able to get all of our work done timely, and we have our next conference on Tuesday. And just watching the circulations come in over the last few days, I'm sure we'll be in a good position on Tuesday. We've issued 3 emergency orders since our last committee meeting on August 28th. And one has been on evictions. We're still trying to get information out to parties in eviction cases through notices that are circulated with citation, notices that can be given by the justice courts at the courthouse, even notices that go out with default judgments where there are judgments. We're especially proud that the governor agreed to use the CARES money to help fund an eviction diversion program. There are only a few of these, handful of these in the country. And the idea is that the tenant can apply to qualify for funds to pay for rent that the tenant has been unable to pay because of the pandemic. And the landlord can agree. They both have to agree, but it's to both their benefits because the tenant gets to stay and the landlord gets paid. So this is a great program. It's $167 million of federal funding that the governor diverted to this. And I'm just pleased as I work with Supreme Courts across the country. It's just so very important that the branches in each state have a good working relationship. And that's mostly not the case. And it certainly is in Texas. And the governor was interested in this. And we visited with him about it over time. David Slayton was very active in getting it done. And so now we have $167 million administered through the Department of Housing and Community Affairs. We've got several pilot sites set up that are making sure that the process works to distribute the money to people who need it. Included with the diversion money is the governor gave $4 million to the court for legal aid for basic civil legal services. And I'm especially proud of that because it shows how far we've come over the years, that the other branches now, especially the governor, see the necessity and the virtue and the efficacy of legal services for the poor, and think they use the money well, and have. Otherwise, he wouldn't have given us $4 million to help with wherever we need it, but particularly with evictions. And the Access to Justice Foundation went right to work within hours to make sure that the money was going to get distributed to grantees and the work was going to get done. So we're very grateful to Governor Abbott for that. We imagine that the eviction crisis is only going to worsen, both in Texas and across the country. And we're not exactly sure how we're going to contend with that as a judiciary, let alone a society. So it's good to have some resources at this point dedicated to that. One of the other emergency orders that we issued was just a renewal of our general emergency order that we first issued on March 13th. Which was just 35 weeks ago that we've been in this situation. But the order seems to be working pretty well, and courts are trying to work through how to change procedures, what changes are good, when can you do remote hearings, when is it not so good to do them. And Justice Bland and I, and I think Justice Busby's going to join us, and I'm sure the court will be anxious to involve itself as well. We want to get the committee's views of these changes in procedures going forward so we can advise courts, direct courts on what's efficacious and what's what we ought to rethink. And in those categories are jury trials, which we're trying just as hard as we possibly can to conduct in person, but it's just very difficult. Houston has probably done the best. I think we're up to close to 60 jury trials, but that's since March. Last year we tried 9,000 jury cases to verdict. And so we're about 5,000 or 6,000 behind at this point. We still don't have a really good manageable way of conducting in-person jury trials. It can be done, but it just involves a whole lot of effort by court staff and lawyers and parties and everybody to get it done. But we're continuing to try, and we're also encouraging courts to experiment with virtual jury trials. We had one, you probably know, in a Class C misdemeanor case in Austin not long ago, and it was just a traffic case, and it lasted less than a day, but the whole proceeding was conducted remotely. The jurors, the parties, the witnesses, the judge, everybody, and got a good verdict that everybody responded well to after the trial was over. And you say, well, so what? That's a traffic case. What about the big cases? Well, the big cases are going to be hard. But last year when we tried 9,000 cases to verdict, about a third of them, not quite a third of them, were in Class C misdemeanor cases. So we're talking about a sizable number of cases that might benefit from virtual jury trials, and the justice courts are actively looking at these things and trying to figure out what they can do. So we look for developments on all those fronts before long. The bar exam was especially difficult, as you may have heard, and we had to cancel the July bar. The September bar went off well with very few complaints. We conducted it. The persons taking it were in hotels, each in a separate room, and it seemed to work pretty well. The exam was given online in October here in Texas, as well as across the country. I think about 30,000 takers altogether. And the reports on that experience were pretty good. A few glitches here and there, but we're trying to carefully gather up reports and look to see what we're going to try to do going forward. I'm guessing the February bar will probably be in person, unless the pandemic gets a lot worse, which it is right this second. But we'll just have to see. I think we'll try to do it in person if we can. But the idea is to keep everybody safe and give some assurance to takers that it's going to operate the way everybody expects it will. The protective order registry that the committee discussed at considerable length, given the privacy issues and other issues involved, has been set up and is functioning. The form is very short, it's just one page, but lots and lots of work went into developing that form, and we are hopeful that it will work very well in this setting. There have been a few technical issues along the way, but we think we're pretty much on the road to operation. And finally, the court ordered a referendum on proposed amendments to the disciplinary rules, the lawyer discipline rules. The vote will take place February 2 to March 4. These changes have been proposed into the process that the legislature adopted during sunset a couple of sessions ago, and the debate and the changes originate in a special group in the state bar, and then are commented on, discussed by the board. Then they come to us to be sent to the membership for a vote. So there'll be that vote in a couple of months. The most talked about change is the modernization of the advertising rules, which notably includes the removal of the prohibition against trade names. And it has gotten some discussion already in the bar, and doubtless we'll get more. There are several other important changes that are in that package of rules to vote on, and I won't go through them this morning, just out of respect for the work that we have to do. But I'm sure you and others will be wanting to look carefully at those as the weeks pass. So that's a report from the court, and I know we've got some important things on the agenda today. So Chip, that's it for me.
Great. Thank you, Chief Justice Beck. The next item is comments from Justice Bland. So Justice
Good
Bland,
morning.
here you go.
Good morning. I have one further announcement. I know that as astute observers of the court as you are fully aware of everything the court is doing to help the state judiciary adapt to COVID and under the leadership of Chief Justice Hecht. What you might not be aware of is just how much work Chief Justice Hecht has put in on a national level to help all state courts adapt to COVID and to develop procedures to keep state courts moving and open as the head of the Council of Chief Justices. And just a week and a half ago, the National Center for State Courts announced that they were going to honor Chief Justice Hecht with the Henry J. Carrico Award for his extraordinary leadership in judicial innovation. And I can tell you that not only have we learned from the other states through the groups that Chief Justice Hecht has convened with Chief Justices from all over the state, but there has been so much that has been exported from Texas to other states to assist in their efforts to keep their courts moving. So I wanted to let you all know about his great honor because he will not. So that's my only announcement, Chip.
Oh, thank you, Justice Bland. And I think a round of applause, virtual applause for the Chief. That is terrific news, and thank you, Justice Bland, for letting us know. We're going to turn now to suits affecting the parent-child relationship and out-of-time appeals and parental rights termination cases. We're joined here by Judge Rob Hoffman of the 452nd District Court, and I know he's on the screen somewhere because I saw him earlier. There he is, right below my box in the Hollywood Squares. And Judge Rucker highly recommends and says great things about Judge Hoffman. And I know, Judge, we're appreciative of your time and adding to our discussion today. And with that, I know Pam's here, but I think Bill Boyce is going to lead us. Am I right about that?
Yes.
Great. Fire away, Bill.
Thank you, Chip. Good morning. This topic is one that we started discussing more than a year ago. We're taking it in small bites. The bite that we are on today pertains to determining whether or not there is a desire to appeal. I'm going to go through an overview of kind of the overall project and this particular piece of it. And I'm going to make reference to three things that you should have in your distribution. One is an August 24th, 2020 memo from the Appellate Rules Subcommittee. Within that memo is an embedded proposed draft of a revised Texas Rule of Civil Procedure 306 addressing recitation of judgment with proposed modifications to focus on the specific issues that we're talking about this morning. Additionally, you should have a letter from Judge Rucker on behalf of the Children's Commission dated August 26, 2020. That was a comment on the memo that was previously circulated and the draft Rule 306 that was previously circulated. Additionally, you have a standalone page in your materials today that Judge Hoffman was kind enough to distribute to us. This is a proposed revision of the proposed draft Rule 306 that's contained in the August 24th memorandum. And I'll certainly invite Judge Hoffman here in a moment to comment on these proposed revisions. I'll offer this disclaimer because these arrived this week. The appellate subcommittee has not met, has not exchanged views in any length about the proposed revisions that Judge Hoffman circulated. So I would anticipate that part of our discussion today is going to be Judge Hoffman presenting his views, and I presume the views of Judge Rucker and the Children's Commission, followed by further discussion. But before we get to that point, I think it may be helpful to give an overview of the particular issue that we're addressing today. We've touched on it in prior meetings. This was referenced at the last meeting, but we postponed the discussion today because of the inability of Judge Rucker or Richard Orsinger to participate in the last meeting and talk about some of these ideas. But in general terms, what we're dealing with today corresponds to stage 1A of the issues for discussion that are identified in the August 24th memo. And specifically, the concept of showing or determining authority to appeal. This goes to the issue that has been described in shorthand terms as phantom appeals. And it goes to the issue of trying to determine whether there is a desire to appeal on behalf of a parent or alleged father whose rights, parental rights, have been terminated. I've given the overview a couple of times, so I'm going to give a shorter overview this time because we've already talked about this some. But I think at its core, the issue that we're talking about today is a mechanism for determining whether there really is an appeal to be pursued. This has been addressed in terms of whether there is an intent to challenge an order terminating parental rights. The draft rule that's embedded in the memo approaches it more in a point of view that asks whether there is good cause to discharge the attorney ad litem tasked with representing the parent or alleged father's rights. The discussion that we've had to date highlights a couple of important considerations that need to be balanced. One is that there are costs, there are systemic costs, there are personal costs to pursuing an appeal of a determination regarding termination of parental rights. That's why it's a very accelerated process. The process needs to have defined contours and not go on forever, leaving family situations in limbo. There are costs in terms of court systemic costs that occur when it is unclear whether or not there's a desire to appeal, and as a result, a protective appeal or a quote unquote phantom appeal may be pursued in an abundance of caution that sets the appellate gears to turning records have to be created, courts have to address it, and so on and so forth. And so the questions measured against a backdrop of a constitutionally protected right with respect to continuing parental rights is, how do we want to address this situation? I've described this before as a question that comes up in a number of different legal contexts, which is, if it's not clear about whether there is a desire to appeal a termination of parental rights, which way does the silence cut? How are courts going to address that? Is there going to be a default determination that the appeal is going to go forward? Is there going to be a default determination that the appeal is not going to go forward? How is that going to work? How is that going to be looked at? When we talked about this before, I think there was consensus on the full Supreme Court Advisory Committee that channeling this discussion into the judgment was a good way to at least have the vehicle to have this discussion and make a determination. This reflects the reality that in some circumstances, intent to appeal may not be clear. In some circumstances, the parent whose rights are being terminated may not be present. Maybe they were never present in the litigation. Maybe they've been intermittently present in the litigation. Maybe there's a change of mind. There's a lot of different possibilities. And so the thought as a threshold matter, as a gateway matter, how do we start the appellate process and come up with some mechanism to say, yes, the appeal is going to go forward with appointed counsel, or no, it's not, was to channel this into the judgment and the discussion, have that discussion, have that threshold determination made as part of a judgment. And so that was the process that led to a proposal to have this appear in Rule 306. At a later time, we can talk about whether Rule 306 is the best place for this or not, but I'm going to put that aside to focus on the threshold issue. If we're going to have a threshold determination about whether the appeal is going to go forward or not, under circumstances where a desire to appeal a termination decision may or may not be 100% clear, what is that going to look like? So the draft that's embedded in the August memo that you have, the August 24th memo, set out a proposed mechanism to deal with that. And that appears at page 7 of the memo, draft Rule 306 judgment in suit affecting the parent-child relationship. And this was structured in terms of deciding whether or not the attorney ad litem is going to continue in the representation. The attorney ad litem either is going to continue, is going to be replaced, or is not going to continue. And I think really the areas of discussion for today's purposes, if you compare the revised draft that Judge Hoffman had circulated against the proposed draft in the memo, you'll see on the helpful red lines in the revised draft from Judge Hoffman that there's some tweaking to make sure that we're using appropriate terminology in terms of parent or alleged father. But the real area of discussion is that the proposal circulated by Judge Hoffman adds subsections 3 and subsections 4 that are not reflected in the draft proposed rule that's in the memo. So to focus everybody's attention, we're looking at proposal for the draft Rule 306 judgment. I guess it's subsection C, subsections 1, 2, 3, and 4. And these are going to be the circumstances where the determination would be made as to whether or not the attorney ad litem is going to continue the representation to pursue an appellate challenge of a decision terminating parental rights. And this goes to the issue of whether there's a desire to appeal. And if there is the desire to appeal, then the representation is required and provided. And so that's the long introduction to try to set up a discussion of what I hope is a focused discussion on these particular issues. I think at this point, it's probably a good juncture for me to first ask the appellate subcommittee members whether there's any aspects of this that I haven't touched on that they want to highlight. And then I would ask Judge Hoffman to offer his perspectives on the proposed revisions to the proposed new rule and the rationale behind them. But before we get to Judge Hoffman, I'll first ask any of the subcommittee members to chime in if there's a point that I haven't identified that they want to highlight for this discussion.
Great. I assume everybody knows how to raise your hand electronically, so we can call on you. I'm on another committee where people are not able to do that successfully. So if you're on the subcommittee and you want to say something, raise your hand now, and you'll be recognized. And while you're thinking about that, I was neglectful in mentioning that I spoke to Judge Rucker last week, and he very much regrets not being able to be here. But he said we're in good hands with Judge Hoffman, and he wanted everybody to know he's doing well. So I passed that along to the committee, and there's a hand up, and it is Pam Barron. So Pam, take it away.
Well, first, thanks, Bill. That was a great explanation of how we got here and where we are. And we have struggled with this as a balance between the parents' right, constitutional right to appeal, to protect their interest in their children, and then the concern that we do have a lot of work going on to pursue appeals that no one is really that interested in pursuing. But I thought that the comments we got very recently from the dean and from the professor, I thought were very helpful. So I'll be interested in seeing what the discussion is on those. But they do try and figure out that balance, but also make sure that the parents are protected.
Great. Anybody else on the subcommittee want to comment before we go to Judge Hoffman? Well, I don't see anybody raising their hand electronically. So unless somebody has something to say from the subcommittee, we'll go to Judge Hoffman. Judge, thanks again for being here.
Sure. Thank you very much, everyone. It's great to be here with you this morning. As you know, Judge Rucker wasn't able to be here, and so I'm going to do my best as the other jurist in residence for the Children's Commission to fill his shoes here today. I wanted to point out a few things from his response to the memo before we get started. I will say that the excellent staff at the commission, as well as Judge Rucker and I, have done a significant amount of kicking this issue around, and I believe that he did a good job of expressing those concerns and thoughts in his response. As I said, I'll just highlight two things, maybe in response to what Ms. Barron just said. One of the sentences from his response is this: it's unclear why the late desire to appeal of a parent who is absent at a critical juncture would deserve more protection than a parent who appears at every stage of the case. So I think in our response, we've done our best to make sure that the rights of these phantom parents would be protected to the same extent as a parent who would perhaps appear for trial, but then no more. So that's one issue perhaps to think about as we move forward. And then also just a note from Judge Rucker's response, he says it's in response to something from the memorandum. The memorandum states that it is not uncommon for parents in these circumstances to reestablish contact with counsel after trial when their circumstances have stabilized and expressed a desire to challenge a termination order on appeal. That would be a parent who never participated in trial or was absent at trial. There are anecdotes of that, but I believe Judge Rucker is correct when he says that the Children's Commission is unaware of any study on legal representation in CPS cases in either Texas or nationally that would support this assertion. So we do have anecdotes of folks coming back after termination from time to time, a phantom parent reappearing and asking to challenge that decision, but I don't think that they are frequent. So with that said, I'll jump into it. We did do quite a bit of kicking this issue around. A lot of thought went into what our response would be to the memorandum. And I think we all agree that the memorandum did an excellent job of getting us where we needed to be. We spent a significant amount of time talking about Rule 306, as Justice Boyce pointed out already. And I'll just run through and tell you, I think, what our revisions do, and then certainly would be able to answer questions if you had any. So at the conclusion of trial, the judgment would be required to contain one of the following express statements regarding an appointment of an attorney ad litem to pursue the parent or alleged father's appeal. The judgment would state that A, that ad litem would continue to represent that parent for appellate purposes, and B, that a different attorney would be appointed to replace the trial attorney to represent the parent for appellate proceedings, or number C, which is the focus of our discussion here today, that the attorney ad litem that had previously been appointed for a parent would be discharged upon a finding of good cause. And there are four subsections that we have proposed, and I believe that they would cover every single circumstance for any parent in a CPS termination trial that had an appointed attorney, whether they were served by personal service or by alternate service. Number one would be for a parent or an alleged father served by personal citation. So proper personal citation, if that parent or alleged father failed to appear or respond, was in a default situation, that would be good cause for the appointed attorney to be released. And the other three sections would be with regards to parents who were served by alternate service. Section 2 would be that the attorney ad litem that was appointed for a parent or an alleged father was unable to, despite diligent efforts, identify or locate the parent or alleged father. So as required in section 1070132 and 1070114, after the attorney did due diligence, they were never able to identify or locate that parent, that attorney would be able to be released at the end of trial through the judgment. Subsection 3 would be in the event that that attorney was able to locate the parent or the alleged father, but after locating that parent or alleged father, that parent or alleged father did not appear at trial on the merits. So the attorney ad litem did their due diligence. They actually accomplished what they were supposed to do. They found their parent, but even after finding that parent did not appear for trial. If that was the circumstance at judgment, that attorney would be released. And then number 4 would be the last proposed subsection, and that being that that attorney did their due diligence. They found their parent or alleged father. That parent or alleged father participated in the case, maybe even participated in trial, maybe even participated through the conclusion of trial. But at the conclusion of trial, the attorney ad litem could report to the court that that parent or alleged father had never expressed a desire to exercise the right to appeal the judgment to the Court of Appeals or to the Supreme Court of Texas. And I believe that language is properly tracking there. So we have talked about every single parent or every single alleged father in this subsection. No parent or alleged father of any child would not be covered by this section. And at the conclusion of trial, then if there was not contact, the attorney ad litem could be released. So I believe that deals with every phantom parent that we would have in the entire universe up until the conclusion of trial. Now, what this process would not cover, and I'm sure Justice Boyce has discussed this before, would be a parent who, subsequent to trial, would then come back within the proper period and request an appeal. So any parent that had been appointed an attorney ad litem who would be seeking to have an appeal would be treated as any other parent in the case who may be indigent. Within the proper time period, that parent could petition the court for a court-appointed attorney for appellate purposes. So we felt like this was a little bit of an expansion on a very well-written draft, and I believe that it covers everything appropriately. Justice Boyce, I believe that's everything I had to say, but I'll certainly be able to answer questions if I can.
Yeah, Judge, if I could ask you just a couple of questions on your C1 through 4, is that meant to be an exclusive list? In other words, good cause means only these things?
Yes, I believe that's correct. You can see there in the draft, there is a strike through of either of, that was Judge Rucker's proposal. And so I believe it would be exclusive. Yes, sir.
Okay. And then on C4, when you were describing it, you said that the parent or alleged father expressed, and then I wrote down, you said at the conclusion of trial, but this paragraph C4 doesn't say at the conclusion of trial. So I wonder if a parent says at the beginning of trial, hey, by the way, if I lose this thing, I want to appeal, and then goes through an entire trial, which is whatever it is, but doesn't renew that statement at the conclusion of trial. Does that trigger C4, the very preliminary expression of a desire to appeal at the beginning of the proceedings, or does it matter when the parent or alleged father makes that statement?
I believe, sir, the way that it's written is that at any time during the appointment, if a communication is made between a parent or alleged father to their attorney that they express a desire to appeal, then that would mean that the attorney could not assert this as a good cause. So on the day that the attorney first meets with their client, if the client says, no matter what happens, I want to appeal, and then that parent disappears and is never seen again for 6 months, at the conclusion of trial, that attorney would not have good cause to be removed under those circumstances. I think that answers your question. I hope it does.
It does answer my question. It raises another one. If the parent or alleged father says at the beginning of trial, no matter what, I want to appeal, and then participates in some or all of the trial, and at the end of the trial says, by the way, what I said before, I don't want to appeal. I withdraw, I retract it. How does the rule treat that situation?
I would think that would, the way it is written may not be accurate to reflect those circumstances and may need to be tweaked. But I would hope that the rule would allow for that express direction to the attorney to be able to move forward with good cause, and the attorney would be released.
Yeah. Okay, great. Bill, do you have, where do you want to go? Do you want to call on members of the committee, or it's your show?
I think going in 2 steps would be helpful. Make sure I'm not on mute.
No, we hear you.
All right. 2 steps would be helpful. Number 1 is the sense of the committee as a whole with respect to whether this general approach in doing this through Rule 306 or whatever number it's given in this way and structuring it around good cause for continued representation. Is that generally, are folks on board with that? And if we get that sense, then I think we can drill down and talk about any comments, questions, concerns, or tweaks that the full committee has for particular subparts or subparts of this proposed draft.
Yep, that's great. On that topic, what's everybody think about this approach? You can either raise your electronic hand or you can just dive in, but electronic hand would be better. Frank Gilstrap.
Well, what other approach is there? I don't know that we've talked about it. Bill talked about this particular approach in global terms. What other type of global approach would be available? I'm not aware of that.
Okay. Robert.
I wanted to maybe go back to a general question, and it was triggered by the proposed rule, the new cause subsection 3. And what exactly is the role of an ad litem? Is it to find the non-located parent, the father typically, or is it to represent the absent parent's interests? And I think that is an important distinction in terms of how the ad litem's role should apply and how that issue should be addressed in terms of pursuing an appeal.
Bill, do you want to respond to that, or Judge Hoffman?
I'll take an initial swing at it, and then Judge Hoffman may have additional thoughts. And I'd like to take a swing at answering both questions. In terms of another approach, what else? What would be another approach? I think that what we had talked about in prior discussions was some kind of a trial court determination of intent, of the parent's intent. And I think there were concerns about trying to go that way because of difficulty in determining intent, either because intent is unclear, because the parent or alleged father is absent or only intermittently present, and so on and so forth. So I would offer that as a response to Frank's threshold question. The thought was, if what we're trying to determine is whether or not the appointed attorney ad litem is obligated to continue with an appeal, that was a more manageable procedurally to get at it that way, as opposed to trying to make the trial courts make intent findings. And so maybe this is an attempt to make this a little more objective.
Oh, you just muted yourself, Bill. You just muted yourself. We can't hear you, Bill.
The attorney ad litem's representation of the interests of the parent or alleged father is going to continue. And it really is, my perspective is we're talking about the attorney ad litem's representation of, an obligation to represent the parent or the alleged father, and whether or not that obligation is going to continue or not. And I'm not sure if that's a full or a satisfactory answer, but that's my thought process. Judge Hoffman may have additional thoughts.
Judge, either question you can address if you have thoughts about it.
Sure, thank you. I'll just speak as to the second question there. So I think once an attorney ad litem is appointed for a parent who is not served by personal service, their duty under Chapter 107 is to do their very best to locate that parent. And if they do not locate their parent, they continue to represent that parent and protect their rights moving forward. If they do locate the parent, then they're obligated under 107 to report that to the court. And if that parent seeks to continue to have a court-appointed attorney, then a hearing will be held under 107. And if the parent is found to be indigent, the court can appoint a different attorney, or certainly can continue that same attorney in the representation, which practically I would think happens across the state in most circumstances. It certainly does in our court. So if the parent has not been located, that attorney represents their rights. If the parent is located and the court continues that representation, then that attorney is client driven as any other attorney would be.
Great. Kenan, you had your hand up, but it doesn't look like it's up anymore. Did you lower your hand?
I lowered it because my comment is more about the text of one of the subdivisions than the general concept. So
Great.
I don't want to prematurely speak.
Yeah, all right, well, save that thought. Roger.
Yeah, thank you. First, I just wanted to say Hoffman's suggestions are very good, and I recommend them. But when you asked about what were the two basic approaches, what I saw at the beginning of this discussion months and months ago was we could either find a way that would allow the judge to justifiably presume that the absent parent really didn't wish to continue the litigation or was never interested in it. And the other way, which is also another proposal, is for the ad litem to basically, as part of the notice of appeal proceeding, have to say whether or not the client ever wanted the appeal. And I see the proposal now on the table, which could be a belt and suspenders approach. We could adopt both, is that the notice of appeal by the ad litem must state or represent that the father or the parent wants the appeal. And if they don't, I don't know whether that means the notice is bad or whether it's just defective, and court officials or the opposing party can challenge it. I think there was some concern over requiring certification by the ad litem as a breach of the attorney-client confidentiality. I leave that for other people to think through. But I think the problem with what we're discussing right now about good cause is when can we have a realistic presumption, that is, based on whatever circumstances you choose, that would allow a permissive inference to the judge. And that is a matter of experience, and I don't have that. So I'll let other people talk about that. Thank you.
Thank you, Roger. Pete Shankin. Pete? Pete, are you there?
Yeah, I am. Sorry. I had raised my hand on a vote, not on a comment. No comment.
Okay. Justice Christopher.
Yes, I was wondering why we needed to have this in the judgment rather than as a change to perhaps Rule 8 or Rule 10. And I was trying to remember why, at what point, I know there was a Supreme Court opinion that said counsel has to appeal all the way to the Supreme Court, which is different from the way it is in criminal cases with an appointed counsel. But it just seems to me a lot cleaner to have a separate order rather than putting it in the judgment. So I was wondering why the committee felt the judgment was the best place to put it.
Great. All right, Justice Gray.
To follow on that, I've just written myself a note. What if this statement is not in the judgment? That always presents the problem. We just had oral arguments this week on a temporary injunction where there wasn't a bond and there wasn't a trial date in the order. What does that mean? And we're going to have the same thing dragging out these appeals if that's where you put it.
My thought would be that if that statement was not in the judgment, finding good cause and releasing the attorney ad litem, that attorney ad litem would continue to represent as they move forward.
All right. Lisa Hobbs.
I think Justice Boyce might be about to say the same thing, but I think the reason why it was included in the judgment is that's the one thing that gets physically sent to the parties. But to answer Judge Christopher's question, I think that was the thought, but Judge Boyce, you tell me if I'm wrong on that.
Justice Boyce and then Justice Christopher.
No, I think that was to follow on the comment. Yes, that was the rationale, and the discussion we had in prior meetings about the vehicle for trying to make whatever determination we're telling courts to make was that there's got to be a judgment. That's a logical and a safer place to put this determination, because if it's a separate order or involves a separate hearing, there are more opportunities for someone to fall away, to not be available, for the order to not get made. It seemed like wrapping it up in the judgment was a more, I don't know if this is the right term, efficient way to go about it, with fewer opportunities for something to go wrong. I think that's the short answer to Justice Christopher's inquiry.
Great. And now Justice Christopher.
Yes, I agree with Judge Gray, because the rule as written says the judgment must contain one of the following express statements. So if I don't have that statement, I do not have a final judgment. And it's going to come up, and we're going to have to send it back, and it's problematic.
Go ahead. Yeah, Bill.
Judgment may be wrong. I'm not sure that makes it interlocutory. With the mandatory language. Now, maybe further consideration about what happens if the required language isn't in there certainly is appropriate, and maybe that justifies some additional tweaks or provisions of the rule, but I'm not sure that would make it interlocutory.
Richard Orsinger.
I'd like to make a specific comment and then the general comment. To eliminate the problem we're just discussing, we could turn 2A into a default presumption or a default rule that the appointment will continue unless the decree says what's included in B or C. So that way the court can't omit A. The court can simply say nothing, in which event the appointment continues, or the court can say B or C, in which event the appointment doesn't continue, and we can avoid this debate. That was my specific comment. My general comment is that the House Bill 7 proposal focused on the notice of appeal as the operative event to decide whether there would be a lawyer for appeal. This work product has changed that focus to the judgment as, at least impliedly, being the event that determines whether there's an attorney on appeal. This rule, though, only decides whether the existing trial court attorney ad litem has the continued duty to pursue the appeal. And if B or C apply, the trial attorney is discharged. But we still haven't made a rule or a decision about whether another lawyer should be appointed for appeal alone. So the House Bill 7 provision encompassed both the question of whether the trial court ad litem should go forward or a new lawyer should be appointed for appeal. And this rule only decides whether a trial court lawyer should go forward. We still are going to need to have some decision made about whether the court appoints a new lawyer after discharging the trial lawyer, appoints a new lawyer to appeal. So as a general rule, I think that this approach on the trial court, as far as the trial ad litem, is fine, but our job is not done until we've handled the question of whether there's a duty on the court to appoint someone on appeal. Another thing is that under House Bill 7, this appellate inquiry, which is triggered by the filing of the notice of appeal, was focused on the appellate lawyer coming forward and verifying with the court the nature of the communication or lack of communication with the client. And what has happened in this rule is that this is more of a focus on defaults, circumstances that speak for themselves, and not so much an inquiry into what the specific lawyer in question has done to find the client or find out what the client wants. Another thing that's interesting to me is that in this proposal, under subdivision 4, the very last paragraph, it doesn't say that the client said they didn't want to appeal. It says the client never said that they wanted to appeal. There's a difference between never saying you want to appeal and saying you don't want to appeal. And I'm not sure that I have a strong feeling about that distinction. I don't think it's just an intellectual distinction, but I think we should recognize that I believe, if I remember correctly, the House Bill 7 proposal was focused on whether the client actually expressed a desire to appeal or not. And so this is a little bit different to say that they never said they wanted to appeal, to say that I explained it to them and they said they didn't want to appeal. Different level of guaranteed due process. I hope that fits in the context. Thanks.
Now that's helpful, Richard, as always. Bill, do you want to take a vote at this point, or about the general approach, or what's your pleasure?
Well, the short answer is yes, but before we do that, I wanted to follow up on Richard's comments a little bit, because I think as reflected in the memo and as reflected in prior discussions, we keep coming back from various angles to the same basic problem, which is if it's unclear, or if the parent or alleged father can't be located at deadline time, which way does the silence cut? What do we do about that? So I think the concern with respect to the certification as part of the notice of appeal was that it was putting the attorney in the potentially difficult position if the client was not able to be located about making a certification or not making a certification. I'm not sure that squarely confronts the issue about which way do we want the silence to cut as a policy matter, balancing all of the choices and all of the considerations that are bound up in this discussion. And I'm speaking in real broad strokes. I think that the sense of the subcommittee from prior discussions is that channeling this inquiry into a discussion in the trial court and in the judgment, when folks are still more likely to be involved, was a way to do that without leaving it to defaults when it comes time to file the notice of appeal, in requiring representations about intent that a lawyer just may not be able to make. So that is in broad strokes, that was why the discussion went off more into what does a trial court ruling or judgment or determination look like, and what's the vehicle for that. I think the point that Richard highlights about the Judge Hoffman's draft, paragraph 2, sub C, sub small Roman numeral 4, is certainly on point. And if we continue down this path of trying to channel this into a judgment language, then we probably need to talk about whether we want, whether the absence of an expression of desire to pursue the right of appeal is enough, or whether we want something more. But I think we're still at the first level, which is there consensus, is there appetite on the part of the committee as a whole to channel this towards a judgment discussion, at least conceptually, in the way that the current draft Rule 306, as with proposed modifications from Judge Hoffman, contemplate.
Okay, we got Frank and then Richard want to say something. Go ahead, Frank. But unmute yourself first.
I'm unmuted, I think. Okay.
You are.
I have a comment on the specific language and then a larger comment on some of the what Bill was talking about. First of all, having gone back and looked at this after some time away from it, I'm very troubled by our reliance on the word locate in C2, 3, and 4. We're proceeding as though if you locate someone, you're in communication with them. And even in the modern connected world, that may not be true. We don't have a slow boat to China, but we do have people on a super tanker on the way to the Gulf, Persian Gulf, that we might know where they are, but we can't communicate with them. And so let's take that hypothetical. It's real easy for me to apply C4. Yes, he's on I located him. He's on a slow boat to China, and he never expressed his desire to appeal. Well, of course not, because I couldn't talk to him. So I think the concept of locating someone has got to be reexamined. On the larger issue of, the policy, which way does the default cut? Bill Boyce put it more eloquently than I do, but the members of the committee, we don't generally do this type work, and we're kind of traditional lawyers, and we believe in due process and notice. So we craft a rule that tends to bend over backwards to give this parent who may or may not be interested in losing his child, whether he's losing his child, the benefit of the doubt, because to all of us, losing a child is probably the worst thing in the world. But the judges have come in and they've raised another point, and that is, in almost all of these cases, the people never communicate. They're you know, and if you're tying up the system to make sure that all these people get some you know, exceptional level of notice, you're tying up the decision on the custody of the child, and that child maybe loses 6 months, in which it could be with the parent, the ultimate parent, but yet we're still trying to locate this parent, and the parent doesn't even care. So which way does the balance cut there?
Thanks, Frank. Richard Orsinger, unmute yourself.
Okay. I would like to say that which way it should cut, I think, depends on our confidence that the notice we're giving is due process of law. What I mean by that is that if the citation adequately explains the right to an appointed lawyer on appeal and the party defaults, then the failure to participate, I think, should cut against a free appellate lawyer, even a free trial lawyer. So I would like to eliminate the phantom appeals. It's a waste of resources, and it delays final disposition of the child's living circumstances, which I think the legislature has considered as an important policy. The thing that I'm perfectly fine with this solution. Having been a member of House Bill 7, of course, I went through all those thought processes that went into that report. Refocusing away from the notice of appeal to the final judgment, I think, is a great idea for the court-appointed appellate, the court-appointed ad litem. I do not think that it is adequate to dispose of the dangling question of when the trial ad litem is dismissed, then what? Do we just have the appeal vanish because of the failure to file a notice of appeal within the requisite time? Because that means that in discharging the trial lawyer, we're impliedly eliminating an appeal by eliminating any person who would file the notice of appeal. I don't know that I'm on board with that. I think that there should be some clear determination by the trial judge that there will not be an appellate lawyer, rather than just an inference that we can draw that by discharging the trial lawyer and not appointing an appellate lawyer, that the trial judge has impliedly decided that there's no right to appeal. So I support this proposal as written, but I have qualms if we don't do something about the assessment of whether there's a right to appointed lawyer on appeal other than this ad litem. But other people who thought more about it may feel like this trial court determination with an implied ruling about the appeal is fine. To me, I'd like to see something explicit. Thank you.
You bet. Roger.
Well, maybe it's my unfamiliarity with the family law process, but I'm curious to know whether there's any requirement that, so to speak, a judge switch horses. That is, that if there's some requirement that the judge, in fact, appoint new counsel to prosecute an appeal after the trial is over. I mean, it would seem to me, and maybe I don't know the family code all that well, that if nothing changes, the trial attorney continues on, and you know, whether he prosecutes an appeal, he does or he doesn't. But that I'm not. I mean, maybe there is, but I don't know that there's a requirement. And I can stand corrected, but I'm not aware of a requirement that the judge, after entering a judgment, must then relieve the trial counsel and appoint a new counsel to handle the appeal. I mean, that may be as prudential reasons. It might be a good idea, but I'm not sure it's required. And even then, I don't think the judges want to get in the business of deciding whether or not to grant or deny a right of appeal. I mean, I think it's up to them to decide whether to appoint or remove the council. But to tell the council, yeah, I mean, it seems to me a great deal of judicial energy is going to get lost if we devise a process that we remove the trial lawyer, and then we have to appoint a new lawyer, and then the judge has to tell the new lawyer for appeal, unless you have some positive indication from the client, don't appeal. It just seems to me we're wasting an awful lot of energy and not accomplishing anything. That's my observation.
Thank you, Roger. Bill, back to you. You want to vote on something, or you want to go into another topic?
I think Judge Hoffman may have a comment.
Thank you,
Okay.
Judge Boyce. I've forgotten how to raise my hand using Zoom because usually I don't have to raise my hand.
Well, here you do. So, and then Richard Munzinger will have a comment.
I'll have to figure out how to do that again. I just wanted to point out a couple of things. The language with regards to location that was mentioned in subsection 3 and 4, the attorney ad litem's duty to locate. The reason that we use that language is because that came out of the statute, the duties of those attorney ad litem's from Family Code section 107. For example, 107.014B 3B requires an attorney ad litem to identify and locate the parent. So that's where the locate language came from the statute. And secondarily, I would hope that the draft is written in this way. And if not, I would hope that it could be written in a way to allow that appointed attorney at the conclusion of trial, at the judgment, to be relieved from the necessity of filing an appeal without direction. As I said earlier, I think if we have a presumption in any other way, as Judge Rucker wrote in his response, we may be giving a parent who is absent completely from the proceedings more protections than other parents if we change that presumption. We don't make folks file a notice of no appeal. I think the requirement is a notice of appeal. So it is a requirement there. And so like in any other case, if a parent does not have an attorney the day after the judgment is signed, any parent, including these parents, would have the right to petition the trial court for an appointment of an attorney for the purposes of appeal. So I think the rule as written would put all parents on the same footing.
Okay, thank you, Judge. Richard Munzinger. You got to unmute yourself, Richard.
I just wanted to comment that some of the discussion is merging the concept of losing the right of appeal with the concept of appointing an attorney for the appeal. The rules of procedure, as I understand them, would be that a final judgment is entered, and let's just pretend for a moment that it recites something regarding the appointment or non-appointment of an attorney ad litem on appeal. No attorney ad litem on appeal is appointed. A notice of appeal still could be filed in the Court of Appeals by either the person pro se or hiring some other attorney. And it just seemed to me that we were merging the two concepts. You're not really depriving anybody of the right of appeal. As a practical matter, you're making it most probable that the person would not appeal. And I think that Judge Hoffman's last comment pointed that out. That's all I have to say. Thank you.
Great, thank you, Richard. Bill, back to you.
So I think where we are is at a juncture to have the up or down vote on continuing with this concept as reflected in the draft Rule 306 with the proposed revisions from Judge Hoffman. And if we cross that threshold, then I think we start drilling down into particulars of the way this draft might operate. And I think there may be some additional things to say. I'm very mindful of Richard Orsinger's comments about perhaps having greater clarity. But before we get to that, I think we're at the threshold juncture of, do we want to continue down this path with a draft rule that looks something like this with this concept?
Yeah, great. Before we get to that, and we'll get to that in 2 seconds, but Justice Gray had his hand up.
To make an intelligent vote on what is proposed, I am curious if we have any data on how many cases we are talking about, because if we don't know how many we're talking about, it really makes it difficult to understand the gravity of what we're voting on. The part of the process that I have seen most affected from what we've experienced at the Waco Court of Appeals has nothing to do with the Phantom case. It is the lawyers that are appointed that miss the deadline because there are special rules that apply to termination cases, specifically the 20 days, and that motions for rehearing do not extend the time period for filing the notice of appeal. That's what we see. Now, that may not be prevalent across the state, but if we're talking about a few cases, this kind of procedure will take 2 years at least to work its way through the judicial system, and there'll be a whole nother bevy of problems that come out of it. I assure you, it always does. And I'm fearful that making a change to the system that we have now that is somewhat working most of the time, in my view, is not what we need to be doing. And so that's why I will be voting for not this proposal, and probably not any proposal that changes the system that is in place now.
Great, thank you. Okay, Richard Muncy, no, you don't have your hand up. Anybody else want to comment? Okay, seeing no hands, Bill, we get to vote finally. So everybody that is in favor of this approach, even though we can have more discussion about the specifics, but everybody that's in favor of this approach, raise your hand.
Chip, this is Scott Stolley. I vote in favor. I can't figure out how to raise my hand.
I'm in the same boat.
Your hand is raised somehow. So somebody figured it out for you.
Can I explain how to raise your hand?
Yes.
Okay, if you go to the bottom of your screen, there's something that says participants. If you click on that, it opens a dialog box, and at the very bottom of that, there are 3 options: invite, mute me, lower hand, and raise hand. So it's in the participant window.
Okay.
And this is Alex. If you're on an iPad, it's on the 3 dots that say more at the top right corner.
Great. Thanks, Alex. Okay. So everybody figured it out?
Chip, do you have a provision for a mail-in ballot?
We do. We're going to get to that next week.
I have not figured it out, but I'm in favor.
Okay, you'll be the 28th vote. Anybody else still having trouble? All right. Everybody that is opposed, now everybody lower your hand that voted. And everybody that is opposed to the general approach that we're taking, raise your hand now. Okay, the ayes have it by a vote of 28-3. So Bill, you have an overwhelming majority for this approach. Now, take us to where you want to go next. If we need further discussion, because of course, what we just talked about did deal with some of the specific.
I think a fruitful next step is to work off of the draft that Judge Hoffman had circulated. We started talking about some of this. I've been making notes, and obviously we'll have the transcript. I guess what I would hope for is a level of certainty that we've identified the potential areas for tweaks on this draft. And then I guess we can see if there's more to vote on for that, or if it's more profitable for the subcommittee to revise it based on the comments and bring back something more refined for a real vote.
Okay. Well, let's see what everybody has to say, if anything. So anybody comments? Justice Gray.
I know that the phrase alleged father is included in a statute somewhere, but why would it not be better to use alleged parent every place that we use alleged father? It would obviously cover the alleged father, but it would also include any other alleged person that is alleged to be a parent.
Okay. I guess Judge Hoffman would be the appropriate person to answer that question.
This statute needs to cover folks who are not just alleged parents, but folks that are actual parents, including mothers and established, presumed, adjudicated fathers as well. So someone who signed a birth certificate is not an alleged father. They're now an presumed father, and they would need to be covered by this statute as well.
And that sort of takes me in the direction I'm going, is the non-traditional parent. I'm thinking of the children that have two mothers, an adoptive parent, a parent that is maybe adoptive, maybe not. It seems to be unnecessarily restrictive to say parent and alleged father instead of parent or alleged parent. And it seems to need to be broader rather than narrower. One other comment about the specific wording, I would change the word in 2C, good cause means the following, a word of limitation, to be good cause includes the following, because I guarantee that there are going to be situations which we haven't thought about that need to be the good cause exception.
Judge, on the issue of parent or alleged father, there probably is not much dispute at the moment of birth who the mother is. But are you saying that as time goes on, there could be an issue about who the actual mother is? Is that where you were going with that?
Well, yes. I mean, you've got court challenges to adoptions. You've got putative adoptions, or at least we used to. I don't know if they're still out there anymore. You've got all kinds of medical advances where you've got surrogate mothers, and there are real questions, I think, coming for the judiciary of who are the alleged parents that we're trying to terminate. And I don't see any downside to changing every place that we put alleged father to be alleged parent.
Yeah. It sounds too complicated for me. I don't know about you. But, that's a good point. Bill.
I think Justice Gray's, Chief Justice Gray's observations are on point in terms of some of the potential issues that may come up at some point. I guess my question and my concern is that the further we depart from terminology that currently exists under the statutes, the more the opportunity there is for disconnect between what this rule does and how things operate under the statutes. And Judge Hoffman may have additional thoughts about that, but my thought would be that the opportunities for problems are reduced if we stick closer to existing statutory language. And if that existing statutory language needs to be modified to address new circumstances, then the better way to do that is to amend the statute than to have the disconnect between the rule and the statute.
Professor Albright and then Justice Christopher.
I was just to add to the complications on parent versus father, I believe that the male to female or female to male, now I'm getting confused. Anyway, when you have a sex change, you can still, if you're a female and you were a male, you could still be the father of children. So I think I raised this last time. I just thought maybe somebody should check with an organization that might be more knowledgeable about these things than we are. But I think these things are getting to be more and more prevalent, and we should probably take them into account instead of being criticized for not doing it.
Thank you, Professor Albright. Justice Christopher.
I would like something in this rule that says the failure to include this statement does not render the judgment interlocutory. I would also like, I think C4 needs a little tweaking. I mean, what if the problem is that the attorney ad litem failed to ask, right? I mean, does this rule create a duty on the attorney ad litem to ask as soon as he has met the parent or father, alleged father, do you want the right to appeal? Here's what it is. I mean, just the way it is written there, never expressed to the attorney. Well, I mean, most clients would not express it to an attorney unless the attorney brought it up first.
Okay. Judge Hoffman and then Lamont Jefferson.
Thank you. Just in response again to the alleged parent issue that Justice Gray raised, at the conclusion of trial, parentage will have been adjudicated. And so there will be an adjudicated mother and an adjudicated father, unless there's an alleged father as the only father that's out there. The code allows termination under one section of adjudicated parents and under a separate section of alleged fathers. So the only parent that could be terminated by this judgment would be a parent or an alleged father. An alleged mother could not be terminated. That person would have to be adjudicated first and then be terminated. So the only person that a judgment would refer to would be a parent or an alleged father.
Great. Lamont and then Frank Gilstrap.
First, thanks for the hand raising lesson. I needed that. Secondly, on the additions, the Judge Hoffman's additions, I share the concerns that that somebody raised about having to assess whether or not the client expressed and intention one way or the other. And I've got a couple of problems with that. One is determining, whether that happened. But secondly, it seems to me like the ad litem should independently be able to determine whether an appeal should go forward without regard to taking into consideration the client's desires, but that shouldn't drive the boat. If the ad litem thinks that regardless of what the client wants, an appeal under the circumstances would be either frivolous or improper for whatever reason, then the ad litem there should not be a presumption that the ad litem must appeal nevertheless. And so I think that I agree that language ought to be tweaked. And I also agree with the comments about, what is the magnitude of the problem that we're dealing with here? Because the rule already allows for the ad litem, even if the ad litem is not in contact with the client, the rule allows the ad litem to make the judgment that I'm going to appeal this judgment. And that's, so 2B says, or 2A says the ad litem can continue the appeal even if there's no contact. But the ad litem ought to also be free to not appeal if the ad litem thinks that they should not, and especially if they're not in contact with the client for whatever reason. So I thought the rule as originally drafted addressed all the concerns that I would have for due process purposes of determining whether or not making some kind of an assessment about whether an appeal should go forward. The person in the best position to do that is the advocate for the client who would appeal. It's not the court. I mean, the advocate's got to assess the entire situation and make a call. So and it's it's not even necessarily the client. Again, I think the ad litem ought to have some discretion on that point. So I like the draft as it was originally drafted. I'm a little uncomfortable with the changes could maybe be brought around there, but and I also think that having this in the judgment is the right place for it.
Okay, great. Frank, then Bill, and then Ken Sullivan.
Well, when I raised the issue of locate versus communicate, Judge Hoffman correctly pointed out that Family Code Section 107 says locate, and that maybe raises the problem to a different level, but I don't think it solves the problem. If locate means communicate, then we ought to say so. If locate does not mean communicate, then we have due process problems, as witnessed the examples I gave earlier. In C4, even if, and I think someone touched on this, even if there we assume that locate implies communicate, as someone pointed out, it says, well, he expressed no desire to exercise his right to appeal. Well, was he asked? When we had a meeting on this earlier, it was some time ago, it was at a hotel in Austin, I believe. We had a discussion where we had some type of statement that the parent had to sign saying, I understand the state's about to take my child, that type of thing. And I complained about it because it wasn't strong enough. Well, we've got to have something like this. I mean, when the person, before expressing his desire to appeal or not to appeal, has got to be told about his rights, and that's not in the rule.
Thanks, Frank. Bill.
A couple of partial answers to the questions that were raised. I'll start with Frank's. I think the assumption that I'm operating on is that this rule drafting that we're trying to accomplish now follows on and improves citation of service that communicates the rights. I think this may have been the point that Richard raised earlier. That's probably not a complete answer to Frank's concern about knowledge about what the rights are, but that may partially answer it. for the question that's come up a couple of times with respect to data. I'm aware of no effort to quantify the degree of the so-called phantom appeals. I would invite Judge Hoffman or Richard Orsinger to speak up if there's some specific data out there that I'm not aware of. And I guess the other point I would make, this goes to Lamont's point about what if the attorney doesn't, the attorney ad litem really doesn't think there's a valid appeal here. I think it's contemplated that later on, we're going to delve into whether and how to fashion some sort of an Anders type procedure to address those circumstances. So I just wanted to put that as a placeholder.
Thanks, Bill. Ken Sullivan.
Thanks. First, my compliments to Judge Hoffman. I think this is a great effort in a very difficult situation. A couple of quick comments. I wanted to echo Justice Christopher's comments. I would think it'd be a great idea for the rule to eliminate any ambiguity about a judgment being potentially interlocutory. I think that's a practical plus that should be considered. And I share the concern about C4 with respect to using the standard of, quote, never expressing the desire to appeal. That concerns me in that, from my perspective, it looks like potentially being invited to a swearing match, and a lot of ambiguity in terms of somebody potentially appearing and saying at some point that they did express such a desire. And then you've got, it just lacks clarity. It's a process that lacks a bright line. While I readily concede it's all very problematic. The last point I'll make is just one that concerns me, and let me note clearly that I'm concerned that I'm not sufficiently schooled in family law to add much here, but it's just a general concern, and that is that I noted various comments along the way. Justice Boyce framed this in terms of which way we want the silence to cut. Frank has discussed it in terms of this issue of, are we talking about locating someone versus actually communicating with someone? And I want to just, I guess, add to that discussion, because my concern is, haven't we really identified various stages in the process in which we have a lawyer who has no client? They are not able to communicate with anyone, and we are expecting them to make decisions unilaterally for that client. And that just strikes me as extraordinary and unprecedented. To what extent are we effectively saying that a lawyer must make a decision for this client? And as a matter of due process, to what extent are we saying that lawyer can unilaterally, without discussion, without communication, make a decision for that client? It's very problematic, and I just wanted to add my 2 cents on those points.
Thanks, Ken. Bill, no other hands are raised. So is there anything specific you'd like a vote on, Bill, for further direction?
I think at this point, what would probably be most useful is to digest this morning's comments and bring a revised draft back in consultation with the subcommittee, in consultation with Judge Hoffman and the Children's Commission, to have specific language that's been hashed out, and I think that would tee up a vote a little more cleanly at this juncture.
Yeah, I think so too. next month's meeting is going to be devoted to deep thoughts in advance of the legislative session. So this would not be brought back until the new year. Is there any timing issue with respect to it? I guess I'd invite the chief's comments or Jackie's thoughts about it. So is there any time imperative that we're working under here, other than we want to try to get it done, obviously?
No, I think that's just it. So it doesn't need to be on a special meeting or the December meeting. It can just come back in due course.
Okay, great. And Richard Orsinger wanted to, yeah, I'm gonna, hey,
Okay.
just take it easy.
Okay.
Gee whiz. First of all, we've got a comment on whatever it is Ken Sullivan has got up on the screen right now, some sort of wood etching of his face that makes him look like he's 22. But other
It's
than
from
that,
the Wall Street Journal. It's a Wall Street Journal drawing, isn't it?
oh,
Listen,
That's
don't make fun of me. I need all the help I can get.
well, now that I know that we can use our Wall Street Journal without fear of copyright infringement, then that's what you're going to see from me. But Richard, what do you have to say?
What I wanted to say as a parting shot to Bill, and also to put in the record, is that this proposed rule kind of drives the statements of the attorney ad litem underground. In the House Bill 7 report, anyone could challenge the filing of a notice of appeal, and then there would be a hearing in which the burden of proof was on the attorney ad litem to prove that they had client authority to go forward with the appeal. In the current proposed rule, subdivision 2C, 2, 3, and 4, the court is making a recital, which presumably is on evidence provided by the attorney ad litem. Because unless the attorney ad litem informs the court will not know whether the ad litem was unable to locate, or whether after locating they failed to appear, or whether they had a communication or a series of communications in which the desire to appeal was never expressed. So I just want to comment that we are not giving anybody any guidance about how the attorney ad litem is supposed to inform the court about the nature of the communications between the attorney ad litem and his client or potential client. And I'm not criticizing that. I'm just pointing out that there's a difference between the House Bill 7 proposal, which puts the attorney ad litem on the spot to come forward with evidence, and this one that kind of has all these implied duties. The final comment I wanted to make is that in subdivision 2C1, the parent or alleged father failed to appear after proper personal citation. That's not going to apply by intent to any substitute service. I think that's what personal means there. And I'm a little troubled by the word proper, because I don't know if that opens a door for some challenge about the propriety of personal service. You know, if you have personal service and you file the citation, you file the certificate of the officer who did the service, it's presumed to be valid. I'm a little nervous about the word proper there, because I think we just are assuming if somebody is personally served and they don't file an answer and they don't file a motion for new trial, they're out. So I don't know if we need that word proper. I'm not criticizing it. I'm just saying let's be thoughtful about it. And this is great work. Thank you, Bill and Judge.
Yep. Justice Christopher.
Yes, I'm sorry. I have one other thought on the way the rule is written. It doesn't require the ad litem to file a motion to be discharged. And so then what I assume is that the judge could discharge the ad litem for the failure of the parent or the father to appear at the trial on the merits, whether the lawyer wanted to be discharged or not. And, you know, I think we have to think about that a little bit. I mean, sometimes fathers or mothers don't show up because they're in jail and through no fault of their own, well, usually through fault of their own, they can't actually appear at trial, even with a proper bench warrant. Because sometimes, depending on the conditions at the jail, even if you do a bench warrant, if you are in trouble and are segregated, they don't bring you. I just think that that's something that we have to think about. Is it an automatic thing? You're not here. You don't get the ad litem.
Got it. Thank you. If there are no other hands, and I see none, we'll take our morning break. Terry, have we exhausted you, or are you okay?
Okay. Thank you for asking.
Yeah. Well, we're going to, in deference to you, and I hope you haven't had any trouble reporting this, but we'll take a 15-minute break and be back at 10 minutes after 11. So if everybody could simonize your watches, we'll see you then.